All rise. The District State of Florida is now in session. I will carry I. Vander, Judge, presiding. All persons having business for this court are heard at God's United States of America, State of Florida, in this honorable court. Please be seated.
Okay, good morning. Welcome to a session of the 5th District Court of Appeal. As the Marshal mentioned, I'm Judge Evander. Let me go ahead and introduce the rest of the panel. Sitting to my right is Judge Jay Cohen, former circuit judge in Orange County, and sitting to my left is Judge Bruce Jacobus, who sat as a circuit judge previously in Brevard County. We have 4 cases on the docket this morning. The first one is criminal. The other 3 are civil. In the criminal case, each side will be entitled to 15 minutes aside. In the civil cases, each side will be entitled to 20 minutes aside. For the appellate, if you first come up here and tell me how much time you wish to reserve for rebuttal, I'll try to help you out in that regard. If you have a cell phone or any other type of electronic device, if you make sure you turn it off at this time so that the oral arguments are not interrupted. And we will first take the case of K.M.O. versus State. May I proceed?
Good morning, Your Honors. I would ask for 3 minutes in rebuttal if possible.
Okay.
My name is Ed Weiss, and I'm here on behalf of the appellant, K.M.O. I apologize ahead of time. There are 5 juveniles, and due to the rules of confidentiality, I have to use initials, and many of the initials are quite similar. K.M.O. was charged originally with robbery via petition, went to trial. The robbery was JOA'd at the close of the State's case to a grand theft and a misdemeanor battery. At the close of all the evidence, the battery was dismissed. However, K.M.O. was found guilty of grand theft. He was adjudicated delinquent and sentenced to a level 6 moderate risk program. The issue on appeal is it's both attacking the grand theft. One is the value of the item. The second issue is the ownership. I want to address the value very briefly, quickly. I believe the 3rd District Court of Appeals case of K.W. v. State is almost completely on point on this case. It involved a cell phone. There was much more testimony as to the value in that case than in the present case, and the court there said there's insufficient evidence. There is, in essence, no evidence in this case as to the value, except for maybe the testimony of the sale price of what it was sold for.
Well, that's exactly right. And, of course, that would be theoretically a fair market value, what a willing buyer would pay a willing seller.
Well, if that's the case, Your Honor, in a situation where someone steals a $1,000 television and all the defendant can get for it is $50.
Well, that's one. There are many ways to prove value. But in this case, it seems that the method used to prove value was what. That doesn't mean that the cell phone wasn't worth more than $300, but it means that the evidence at trial was that it was sold for $300.
And I agree that the evidence was it sold for $300. But we don't have any testimony as to condition or anything else. And
what difference does it make? We know that it sold for $300.
What if the phone is only a $50 phone and he sold it for $300? That doesn't mean the victim.
A willing buyer paid a willing seller $300.
But the petty theft statute is designed to what was taken from the victim, not what was obtained as a result. It's what's taken from the victim.
It's the value. It's to establish the value.
And the value of the phone from the victim is what the fair market value of the phone is.
And your argument would be because it's stolen, it probably didn't really get fair market value, correct?
It's very possible.
I mean would that be something a jury would consider?
Possible.
So we could say maybe the floor is $300.
But we don't have any testimony. Also, this court's case of Smith v. State also establishes that value was not proven in this case. The defendant's admission, and not only that, but it's an estimation. He said, I sold it for like $300. So it's not even a guarantee that he sold it for $300.
It's kind of a filler word sometimes, like. I mean,
it can be a filler word. It can also be an approximation.
That's right. And we weren't there. The trial judge was there.
And it was a statement admitted through the officer.
Right.
And it wasn't a taped statement. So that's the situation. However, the main point on appeal is...
Was the officer cross-examined and was there...
He was cross-examined, but not really as to the statement, no.
Okay.
The main issue in the case is the ownership. And without proving ownership, the value is a moot point. In this situation, there's no doubt that the true owner, the rightful owner, is not established. The issue is whether or not who is the temporary owner or the bailee. And the facts of this case are very important because it establishes that the case in hand is more similar to State v. Anders and DRH v. State than it is RC v. State. Unfortunately, I looked and couldn't find a case anywhere directly on point with the facts we have here.
How would you distinguish the RC case? I mean, you have a person who's found a bicycle, they're going to return it, they have it on their property, and someone else takes the property.
Well, the most important distinction between the two cases is who found the device, the item. In RC, the listed victim is the person who found the bicycle. In the instant case, the listed victim is not the person who found the phone.
Well, do you think in RC, do you think the results would have been different if, say, the person found the bike, was heading out of town, so they said, you know, look, I think I found this bike somewhere, I think maybe if you could bring it to the school or bring it, you know, wherever, and see if you can find the owner, you know, says this to their neighbor. So could you go ahead and see about getting it back to whoever, maybe we can find the lost owner, and then that person heads out of town. Do you think the result would have been any different in that case? Because the finder is different than the person who had it taken from their possession?
I think it depends. I mean, unfortunately, that leaves too much of an open door because I don't know if the neighbor saw it taken. I mean, what if it was left out and the neighbor didn't realize it was taken?
Well, even in this case, try to get the initials right as well here.
I listed them A, B, C, D, E, so
Yeah.
it might be less confusing.
So MN finds the iPhone.
Correct.
All right. So say MN is heading out of town, so he says to JG, could you bring it back to the school tomorrow and see if, you know, we can find whoever owns it?
If K.M.O. took it from JG's hand?
That K.M.O. did take it from JG.
No, he did not. He took it from MN. MN is the one who handed it to K.M.O., not JG. And that is a vast distinction. And in the state's brief, they...
Why is it a distinction if both MN and JG have an intent to return the phone to the rightful owner? Well, why does it matter who it's taken from?
I would compare it to someone chasing down a purse snatcher. If someone chases down the purse snatcher, sees someone steal a purse and chases down the person who stole the purse, that doesn't make them the rightful owner of the purse. That just makes them a good Samaritan. As trial counsel aptly argued, they're nothing more than a good Samaritan.
Well, how about you have the person chase down the purse snatcher, wrestles it away, takes the purse, is bringing it back to the owner, and then someone takes it from that person. Why wouldn't it be?
And again, that's not the facts we have here. I would agree in that situation you could say that's a theft, but we don't have that here. What we have here is MN gave the phone to K.M.O. If JG gave the phone to K.M.O., or if K.M.O. took it out of JG's hand, I would probably agree that
Would you agree that the evidence was that both MN and JG intended to have that phone returned to the rightful owner?
Everyone on the bus could have had that intent to return the phone.
And that they both had at one time temporary possession of it?
I would agree with that, yes.
And would you agree that that temporary possession would be more rightful than that of your client?
At the time JG possessed it, correct. But he was not the ultimate possessor at the end. Now, I would make this analogy.
But the test is whether the person from whom the item was taken had a superior interest.
Correct.
So if both MN and JG had it, and both MN and JG at one time had temporary possession, and both had the intent to return to the rightful owner, then how is it that both MN and JG did not have a superior interest to your client?
Because MN is the one who found it. MN is the one who gave it to K.M.O. This was not taken out of MN's hand against his will. MN freely gave it to K.M.O. JG only temporarily possessed it to see if he could identify who's the owner of it. I will make the example of, let's say a group of people are walking along, and 20 people. And one person finds something and says to the other 19 people, hey, I just found this. And each of the 19 take possession, look and say, don't know whose it is, here, you take it back. And it keeps getting handed between them. And every time it's handed to one person, it's always handed back to the person who found it. It doesn't make all 20 people the victim under the law. It only makes that last person. Now, if one of the 20 had it taken out of their hand, they're the victim. But if it ultimately is given freely to that final person and that person leaves, it's the person who gave it to him or the person who found the phone or the item that is the victim. And that's the very important factual distinction in this case, is that MN freely gave the phone to K.M.O. And the state's own brief, where they state that the person who last possessed the lost item with the intent to return it to the proper owner was the one with a legal and possessory interest. That last person is MN. And under the state's own argument, MN is the victim and not JG. And under that, and the facts of this case, every time it changed hands, it went from MN to the person and back to MN. JG admitted his first time possession was a very short possession, gave it right back. His second time was simply to leave a message. He's not even the one who dialed the contact. The third time was on the bus, went right back to MN. The fourth time, it was again a short possession, back to MN before it was given to K.M.O. At no point did JG possess it for any length of time to establish anything more than that temporary ownership only when he handled it. Just because he agreed with MN that it should be returned doesn't automatically equate him to a victim. And thus, we would believe that the state has failed to establish the owner of this item, and I see I have 5 minutes, and I would like to use the remainder of my time for rebuttal.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I am Carmen Corrente with the Attorney General's Office, and I wanted to read from the RC case the definition of ownership, which is, in this context, is a term of art, meaning any possession which is rightful as against the thief. Now, the thief in this case, the defendant, appellant, admitted, all the way down the line, he admitted that he took the phone, it wasn't his, he knew it wasn't his. He admitted keeping it, selling it, and making a profit off it. Never denied any of that. So the evidence at this point has to be viewed in a light most favorable to the state. We have an admitted thief who took it from somebody who was who had the ownership, temporary custody or control of it, and the rightful owner at that point.
Let's say that they're on the bus and the phone is in the back of the bus, and the defendant is in the front of the bus, and so the phone is passed up, row to row to row. Is every person on that bus until it gets to the defendant a victim? And so the state can just take a dart, throw it at initials, which is apparently what they did in this case.
Well,
and that's the victim?
I think the victim in this case, if I can answer it first with that, the victim in this case is because this was charged as a robbery. It's actually the one who went after the phone and who ended up with a battery and an altercation trying to retrieve it. They would be hard pressed because the bus was gone by then. Everybody else on the bus was gone. So I think we have to take this case and the facts of it with that understanding, with the circumstances. Now, if we're moving to a theoretical question as to how many victims there could be, I think the state only needs to pick one. Anyone who has a possessory interest. This is a property crime, at least now, not at the robbery, but this is a property crime at this point. They have to prove the ownership as far as custody, possession, and control for the purposes of who's the thief and who's one who had taken it from possession. We've got a situation where you can ask anybody to show, let me hold that, let me see that. Someone tells me they find something, I want to look at it, it's pretty neat, and he hands it to me. If I walk away, I can't be charged under appellant's theory. I can't be charged with doing anything wrong. The person who gave it to me is not the owner, and that could have gone through 3 other people. Before I get it, it doesn't matter. As long as it's handed to me, then if it doesn't belong to any of those people, I can keep it. I can sell it, and I can do anything. I think that's a result that's not anticipated by legal precedent. That's what happened here. They were handing it around trying to figure out who owned it. This person gets it and just tries to leave with it and takes it to temporarily or deprive the owner of custody. So I think the facts are really clear. If I can spend a moment on value, all of the cases say, and all of the cases who discuss condition and when it was bought and all that is are those cases that don't have a value at the time of the theft. This was within 24 hours or 48 hours of the theft. He admitted he sold it for $300. If you look at I think it's page 2 of the record, where it's the officer's affidavit, he doesn't use the word like in there. I think that was something that was in the testimony, but he said it was sold for $300. That was how much it was sold for.
Well, but the testimony,
In testimony, he goes like
testimony was
$300.
like $300.
But that, I think, if you compare it with the actual sworn statement that was made at the time, that would be something that he referred to without looking at it.
But did the sworn statement come in evidence?
In the sworn statement, it's page 2, and it's, he exited the bus, the suspect stated he sold the phone for $300.
Did it come into evidence?
Oh, no, it didn't come into
All
evidence.
right, then you need to restrict your argument to what came into evidence, which was his testimony.
Well, we're trying to interpret his testimony as to whether the like was a filler or not. as we
Can't
discussed.
interpret it by referring to a matter that wasn't in evidence.
All right. Your Honor, I think the evidence, though, when viewed in a light most favorable to the state, actually shows a robbery, but in this case, we're dealing with a grand theft. It shows an amount. It shows a taking, a definite taking. Otherwise, we would have many situations where it wouldn't be a crime to walk away with property. If there are no other questions, we'd ask you to affirm.
No questions? All right, thank you.
Just briefly, my argument isn't he's not guilty, it's they didn't prove the correct victim. The victim in this case is M.N. And just because he's admitted to a crime doesn't mean he's guilty of this offense. And the perfect case on that is DRH v. State, where the 4th District reversed. In that case, you had the defendant confess, I tried to break into that red Camry. You had a victim who said, I own a red Camry. You had it on video where you see the defendant trying to break into a red Camry. But you didn't have, when the victim was put on the spot, the victim said, well, it looks like my car, I just can't tell if it's my car. And the 4th said, well, we have no doubt that he committed the crime, we just can't connect the car to an owner, and therefore we have to vacate the judgment and sentence. And that's what I'm arguing is, you have to prove that of which you alleged. They alleged JG is the victim. JG is not the victim. MN is the one who found the phone. MN is the one who gave it to K.M.O. And they say, well, and Judge Cohen hit the nail on the head, if it was shoved up and every single person touched it, not everyone under the law is a victim.
Let me ask you this. If you had a law firm, 2 partners, wasn't incorporated, and someone stole law firm money from one partner, are they stolen from both or just one?
Unfortunately, I don't know enough about incorporations.
Well, I'm saying it's not incorporated because...
That's what I'm saying, I don't know.
Because if you look at these two as being in a joint venture together...
I don't think you can make that comparison that they're in a joint venture together. I mean, if they're on a treasure hunt and let's say...
Common purpose, return the phone to the right owner.
The one who found it had that purpose. And although not objected to, and I realize it's not preserved for an issue on appeal, however, there was a lot of hearsay admitted without objection. And if it weren't for that, that would be another issue on appeal because they couldn't have established it because MN never testified below. Okay. But MN is the victim in this case, no matter how much the facts sway another, they try to argue JG is, just because JG possessed it for a short time to identify the owner doesn't make him a victim forever. The person who handed the phone to the defendant is the victim in this case, and that is also the person who found the phone, and that is MN, and therefore the case should be, the sentence should be vacated. Even if this court only reduces it to a misdemeanor, he's already served more than the time he could have served on any conviction on a misdemeanor, and we'd ask that he be discharged from any remainder of his sentence. Thank you.
Thank you.
Thank you.